going to go ahead and dive right into our content today. We have a lot of information to cover. I want to welcome our participants from far and near on our COVID Q&A for your business webinar. We are going to be focused mostly on an overview of what you may already know about many of the laws and changes that have been enacted over the last, wow, can you believe it's only been about 30 days? And so I know that there are some clients in on the call. There are some non-clients, so I want to welcome everyone. I want to definitely touch base with some housekeeping notes. You are all muted. You can feel free to chat in the chat window that you have access to. We will be taking Q&A, which will be the larger part of our conversation because we expect that many of you have attended some information. So we'll provide some overviews, but we really wanted to speak to many of the questions that we've been receiving and also any of the questions that you have. Because the laws are changing so vastly, and by the minute, I just received another update that hopefully we'll be able to speak to later. There may be some questions we can't answer, but we'll definitely ensure that you do get those answers if we aren't able to answer those at this time. So let's dive right in. Many of you might know our presenters, as we both did a great job of promoting our presentation to gain all of the insight and the Q&A from our clients and non-clients. My name is Lisa Perez. HBL Resources is my full-service human resources consulting firm. While I'm based here in Miramar, Florida, we do have clients throughout the United States. HBL Resources has been around since 2011. I hold 2 certifications in human resources, one of which that I've had since 2002, and I have over 25 years of experience. My colleague, well-respected CPA, and my own personal CPA, which says a lot because you all know I'm very picky, is Michael Bayere. He is the founder of CISA Assurance, licensed CPA, not only here in Florida, but also in Virginia. He holds dual master's degrees in accounting and IT. And correct me if I'm wrong, Michael, you also are a forensic accountant as well. Is that correct?
Yes.
I always think that that's a great thing to add. And Michael brings over 20 years of experience. So together we are able to really discuss a broader overview of the laws and how they relate to your business. So let's dive right in. Our overview for the webinar is going to be information as current as today, right? Things are coming in hot off the presses, the employment laws, the federal programs that are being expanded by the moment, and then, of course, the Q&A. So our overview from an employment law regulation perspective, we'll talk about the SFCRA, how that relates to all the other products and services and funding that has come out of a result of that broad picture. That was enacted in March 18th this year. And we've seen the expansions in all of the other laws and acts, the EFMLEAA, we'll talk about that, the CARES Act, right? We're going to use acronyms a lot today. And then we'll talk about some of the employee relations considerations that we have because of the laws we already know and have to comply with in our businesses. Then we'll switch over to the federal programs overview, all of the economic support and relief that is coming as a result of the FFCRA, the economic injury disaster loan, the Paycheck Protection, how does that coordinate with what we're doing in our workplaces, the Express Bridge loan, and also some SBA debt relief programs that are coming out right now as well. And then the crux of our time, we're going to hold 20 minutes. Usually, it's only that last 5-10 minutes. We really want to look and speak to 20 minutes worth of Q&A, both some that were submitted prior to our webinar, some that you'll be able to submit during the webinar. So let's dive right in. I'm going to use a lot of acronyms, like I mentioned, the Families First Coronavirus Response Act, right? Also known as what started out in legislature as HR 6201. You might have seen that name. So those are one and the same, in fact, and that was enacted on March 18th last month, right? So that includes some emergency paid sick leave provisions. It was effective April 1st. So as of April 1st, we can start to use those sick leave benefits. And those are provided to employees who are sick and also have daycare centers and cannot take care of their children. That's an expansion of the EFMLEA, right? So we think it's an expansion of the Family Medical Leave Act. So it's Emergency Family Medical Leave Expansion, right? So it adds more benefits. So we'll talk a little bit about the details on that in a moment. What those two things do is provide paid sick leave at the employer's the employee's regular rate of pay. That's because now we are unable to work because we're being quarantined. And these are pursuant to a healthcare provider's governance, not necessarily a self-quarantine, but we'll talk about that as it relates to ADA and who might be in our homes and families and things of that nature, because all of those things are very important. It also provides a 2 weeks period of paid sick leave at 2/3 of the employee's rate of pay, but that's to care for an individual who's been quarantined or whose childcare has closed. So there's some differences there in terms of whether it's the employee or whether it's someone related to the employee or someone with whom they have care for. And again, we're I hate to use the word assume, but we're taking it for granted that there has been some knowledge base going on throughout. So we're hitting some highlights so that we can focus on what does this mean to us in our businesses. Now, you're a covered employee. There are some public agencies that are covered regardless of the number of employees. So quick disclaimer, this information is using our federal government programs, acts, regulations. There may be changes based on your state laws. For those of you who are calling in from other states, from states that have local and county city ordinances. I know many of my clients in California have a lot of codes and enforcement that's happening at a local level. And some of you may be union houses. So your collective bargaining agreement or your CBA would be part of this conversation. We can't go into that much detail. So we're really just providing the federal overview as it relates to your business. In addition, it does relate to private employers, less than 500 employees that are full-time and part-time. Now, there are several calculations behind the scenes, right? Do I add seasonal, all of that? But for the most part, full-time and part-time is a good starting point for that determination. It includes small businesses with less than 50 employees who may qualify for an exemption. And that is still being decided. I actually think I just saw something come in from the SBA or the Department of Labor that's actually defining what that exemption looks like. And for the most part, the language is if the exemption of the FFCRA, these benefits, jeopardize the business viability. And we've heard that before with family medical leave. We've heard that in terms of, undue hardship. What's that definition going to be? We don't know. So that's why it does say TBD, to be decided. They're expecting that to come out now in April. So when we know, you'll know. If you get our newsletter, you'll definitely get that as it comes hot off the press. For covered employees, who are they? They need to be employed for at least 30 days prior to the enactment, right? So we want to make sure if you have employees who maybe you started to see this coming in February, maybe you laid them off and terminated, maybe you furloughed, what have you, as long as they were employed and you bring them back for at least 30 days, then you can take advantage of these provisions. The employers can exclude some employees who are either healthcare providers and emergency first responders. I am not a medical professional. We can't speak to that. I do know one of my clients is a dental practice, so we need to tie into the essential versus non-essential definition there, and we can certainly, get that information, whether or not dentistry and other ancillary medical support services qualify, eye doctors, things of that nature. So what are the reasons for the sick leave to be taken? Again, the biggest purpose for this is because there is a local quarantine or an isolation order because of COVID-19, specifically for that purpose. They've been advised by a healthcare provider to self-quarantine. That's critical because I just this morning saw some new information about that stipulation. I can't, as an employee, just say, hey, I want to self-quarantine. There's got to be some interactive process, and we'll get to that with the ADA process, hopefully at least in an overview. Or they're caring for an individual who's subject. My spouse, my child, my grandmother who lives in my home is subject to the order, and I need to care for them. That provides that paid sick leave. Or a child whose school or daycare has closed, right? This is a very real situation. Again, this morning, I wish I had enough time to bring it in, the expansion of what that child care space looks like, the nannies, the in-home health, in-home care providers. I believe there's been an expansion or a definition of whether or not they are included. The last thing I read, it looked like it said that they were. So keep that in mind, and we'll be updating our newsletter in the next day to provide some insight on that. Now, in addition to that, they're experiencing any other substantially similar condition. Now, this is subject to the COVID-19 situation that we have going on. And feel free to jot down your questions. We will be reviewing the chat at the end and then answering some that are coming in as well. So let's talk a bit about the emergency FMLEA, because it is an expansion. It is part of the part of the FFCRA, and if you have 500 employees or less, you are subject to it. Again, we are looking at the expansion, or that exemption rather, for employers who are less than 50, but we're still waiting for some guidance on that. That relates to this as well. You, again, need to have the first 2 work weeks unpaid, but they can use the emergency paid sick leave, right? Maybe your employees have PTO on the books already for the first 2 weeks under the emergency FMLEA. It's unpaid, but they can use those other benefits because this act doesn't give them the pay, it just gives them the time off, much like FMLA does. Gives you time off, but not the pay. So with the EFM, I'm just going to call it FMLEA, okay? It does coordinate with the FMLA. This is new leave reasons. It does not say I have to give another 12 weeks, okay? For those of you who are subject to FMLA, you know you've got to be at least over 50. We're still waiting to hear on this, how it coordinates with employers under 50. However, you want to be prepared. It is an expansion of the reason for leave, not the time off. So FMLA is 12 weeks. It remains to be 12 weeks. If an employee has already used their FMLA leave for the 12-month period, however you calculate that 12-month period, they are not eligible for this FMLA leave, okay? So you have to be very cognizant of whether or not that employee has taken all of their leave time. If not, they can take up to 12 weeks under this expansion. Well, what does that mean when they come back? Maybe I take 8 weeks now, and when I return and everything gets back to what will be the new normal, they have the additional 4 weeks, or vice versa. So it's up to 12 weeks in coordination with both EFMLEA and FMLA. So the reasons, again, the employee can only use it for leave to care for his son or daughter whose school or place of care is closed due to COVID-19. It's up to the 12 weeks. We've seen an expansion of this as well. And again, the initial 2 weeks is unpaid. The remaining 10 weeks is paid at 2/3 of the employee's regular rate of pay. So there is some relief there, not to have to pay the full hourly rate of pay. So the CARES Act, as you can see, right, you have the FFCRA and then the CARES Act coming in combination. This basically provides and appropriates, the number's growing, $350 billion, I'm sure you've seen that in all of the news, for small business administration programs. Well, here are some key provisions under that CARES Act. You've heard about the one-time cash payments, and much of this we are going to segue to Michael to discuss in some more detail. The one-time cash payment falls under the CARES Act. The expansion of unemployment benefits. Here's how it relates to our employees. Typically, the rate was about $200 and change. Now that under CARES Act, there's an additional $600 a week and an expansion for up to 13 more weeks than what it already was. Now, I want to make sure that you know this. Obviously, there's a lot going on, especially here in Florida with the website. People can't get in, things of that nature. HBL Resources does have a paper application that in the event you have to, have those tough conversations or already have with your employees, you can provide them at least the paper application, and the instructions are there on where to mail it and what have you. We are recommending that they be mailed via some kind of tracking system like the United States Postal Service overnight or 2-day express mail, that kind of thing, so that you know it's been received in the event you cannot get through on the website, which has been a constant. So it also expands to small business aid, right? Gig workers, freelancers, self-employed are now eligible for unemployment. For those of you small businesses who might have employees or workers, I should say, that are 1099s, you want to inform them of that, right? Your web developer may or may not know what's going on and what support they have. 1099 self-employed independent contractors now fall under unemployment, and Michael will speak to some of the other grants that are available for them, the EIDL, the EBL, the SBA, debt forgiveness, and things of that nature. So we're going to talk about the Paycheck Protection Program. So I just wanted to kind of give you an idea what this CARES Act really was doing. It was also providing corporate aid, right? Not just for small business, but for large organizations as well. It's the public health officials and all of the testing programs. It's supporting the education system and the food programs that you see showing up in our own backyards. So how does it relate to employee relations? Well, I want to make sure that you understand just because it was enacted so much later, even if you started to lay off employees or furlough employees from March 1st or later, you can rehire them and get relief under the programs that Michael Bayere is going to speak to. So we can reemploy them quickly, maintain that workforce, maintain that salary level for them to kind of, I guess, I'm no economist, but, keep that economy stable and keep some money flowing into our employees' pockets. They would be eligible as well for the paid leave under the EFMLEA. So keep that in mind. There would be, really not, kind of like no break in service, but remember that 30-day window. It has to be at least 30 days of the last 60 calendar days. So let's quickly go over OSHA, ADA, HIPAA, and GINA, and I'm really going to speak mostly to the things that are happening now that are relevant. We, again, are anticipating that you've either attended a previous webinar of ours, attended one of our workshops, have an overview of these laws. So as they relate to COVID-19, under OSHA, we as employers have to provide a workplace free of health and safety hazards. We realize that. So we've got to maintain that same thing in light of COVID. In the event you have an exposure situation, someone comes to work and you believe that they've been exposed, and we'll talk about that in the Q&A section. You have a responsibility to have your office areas sanitized after 24 hours, right? Because you want to be careful of that contact window that the CDC continues to change, but is what it is right now. So, and you want to protect your workers from having to come to work, especially if they have a fear that there's some danger of infection there. So employees can say, no, I'm not coming to work because there's been an exposure, you haven't cleaned the place. So that opens up a whole kind of new window. But I wanted to mention that as it relates to OSHA, we will talk about a little bit of that, hopefully, if we have time in the Q&A. Under ADA, Americans with Disabilities Act, right? We do not have guidance yet about whether an exposure or a positive result of COVID-19 is covered under ADA yet as a disability. We are still waiting to hear that. But in light of that, you are permitted to inform employees that there has been a possible exposure in the workplace, but you must still maintain confidentiality. You can't say, hey, Susie Jane has COVID-19, right? We can't do that. We can inform them that there's been an exposure incident. They may have been exposed, and then we can take the next steps as necessary. And I'll talk to you about how to get those resources after the webinar. So employers are permitted actually to measure body temperature. We've seen a lot of employers get those test strips that go above the head to make sure their body temperature. But remember that the CDC is saying that's not the only way we can tell. But we do have guidance under ADA and the Department of Labor and the EEOC that we can do that if you choose to, if they're experiencing influenza symptoms. You cannot ask them about exposure with their family members. Remember that that's something that is a privacy issue. So we'll go ahead and segue. That information about COVID-19, any exposures, any illnesses are covered under their confidential medical record, right? So if they have a sick note, if something's coming in and we've got that information, that doesn't go in the personnel file, that goes in their confidential medical record. For those of you who've taken my classes, you know that that's the case. So HIPAA. These are where the privacy issues really start to come into play. We are permitted to ask the employee themselves if they've had a symptom or if they've been exposed or if they have a positive test. But again, we are prohibited from asking about family members. Well, what about your son, your daughter? Now, if they disclose it, that's one thing. We still want to remain confidential and ask only if they've been exposed, not by whom or from whom. Okay. So that was a lot of information. Michael, I went 5 minutes over my allotted time. So, and I know you've got a lot to talk to. So you've got the controls. And then after your section, we'll go into some Q&A.
Thank you, Lisa. And I want to welcome all our attendees. Thank you for joining us today in this session. And I hope you are all staying safe, you and your loved ones. And hopefully we get through this sooner than we can foresee. In this session, as Lisa rightly mentioned, I will be covering provisions that relate to funding opportunities that are being made available through the SBA from the provisions of the CARES Act. There are some provisions or benefits that relate to individuals that I'm not going to cover in this session because of our time. But if you do have any questions that relates to benefits to individuals, please feel free to ask those questions when we get to the Q&A session. There are other provisions, benefits that relates to tax benefits for businesses. I'm not going to cover those as well because of the time. But if you have any question relating to tax benefits as it relates to the CARES Act provisions, please feel free to ask them during the Q&A. If we cannot cover them all through during the Q&A, please feel free to reach out to me, or you can go to my website. There are other information in detailed form that you can access through the website as well. So in this section, we have 4 different programs under the SBA that are providing funding assistance to businesses, small businesses in particular. We have the PPP, you must have heard, that stands for Paycheck Protection Program. We have the EIDL, which stands for the emergency, economic injury disaster loan, economic injury disaster loan, EIDL. And then you have the express bridge loan pilot program, and then you have the debt relief. So I'm going to take them in turn, starting with the PPP. The PPP is essentially are designed to help businesses to retain employees on their payroll during the crisis.
There you go.
So, who is eligible for the PPP? If you are a small business of not more than 500 employees, you are eligible, or you are a sole proprietor, or an independent contractor, or self-employed person, or you are a private and not-for-profit organization, or a veteran organization, or a tribal business, you are eligible for the PPP, provided you meet all the other criteria, meaning you are in business as of February 15th this year, you are in operation, you are eligible. And what do you get if you apply for the program? You get the lesser of $10 million or 2.5 times your average payroll cost. And we are going to get into what constitutes payroll cost shortly. That money you pay back if you are not qualified for forgiveness. I mean, if you are not forgiven the entire amount, you pay back within 2 years. But it is possible that you get the entire amount forgiven. And we're going to touch on that, what you have to do in order to qualify for forgiveness. Now, what can you use the money for? You have to use it for payroll costs, essentially. At least 75% of the amount has to be spent on payroll costs. And then the rest, 25%, you can spend on rent, utilities, interest on mortgages. Now it is interest on mortgages, not payment of principal. And then other costs that are necessary for the operations of your business during the crisis. Those are eligible costs which you can spend the proceed on. Now, what constitutes payroll cost? Payroll costs includes the compensation you pay to your employees that are each earning not more than 100,000 per annum. If you have any employee any more than 100,000 per year, you have to exclude the cost of that employee salary from your calculation of payroll cost. Payroll costs also include cash tips or equivalent, payment of vacation or leave, allowance for separation or dismissal, payment of provisions of a group plan, a health plan, and retirement plan, as well as employers' payroll taxes. So all of those qualify as payroll costs. Any money you spend on this for a period of 8 weeks, starting from February 15 through June 30th, all of those are qualified as payroll costs. It has to be for 8 weeks. Now, in addition to payroll costs, you can, for sole proprietor, self-employed, independent contractor that don't have employees, to incur the previously listed items, payroll costs include wage to yourself, commission, income, earnings as a self-employed individual, or compensation that you typically will get as a self-employed individual. So those are what constitute payroll costs for a non-employer of persons. Now, let's move on to, before I move on to that, I want to touch on the issue of payroll forgivable portion of the PPP. Now, you must have heard that you might not need to have to pay back the part or the entire amount. Yes, it is possible you don't pay back the entire amount, provided you spend the money on forgivable purposes. And what constitutes forgivable purposes? Forgivable purposes include payroll costs, utilities, rents, interest on mortgages, and other necessary costs. Those are forgivable costs, purposes. But like I said earlier, you can't spend more than 25% of the total amount on rent, utility, interest on mortgages, and other costs. So you can spend a maximum of 25% of your total amount on this other cost other than payroll cost if you want the total amount to be forgiven. Now, if you spend outside of that 25%, you have to pay back the excess, and you have maximum of 2 years to pay back what is not forgiven you. So let's move on to the next program, which is the, and I'm sorry, this is flipping up and down, economic injury disaster loan. Who is eligible? Typically, the set of entities that are eligible under the PPP are eligible under the EIDL. So in addition to being eligible as one of these listed entities, you have to also meet the requirement for SBA 7A loan programs. The lists are quite elaborate. If anyone is interested in that list, I can send us the link to that set of requirements. We just go ahead and post the link here on the chat box. So if you have, all right, so that's the link to the list of the set of requirements for SBA loans. So you have to meet those requirements in addition to be one of those entities listed. What do you get under the EIDL? You get a maximum of $2 million depending on the assessment of your situation by SBA. So if your assessment says you need 10 million for your situation, of course, you get a maximum of 2 million. If your assessment says you need just $500, $500,000, that's what you get. But you can't get more than 2 million. You can get an advance of 10,000 immediately you finish processing so your application within 3 days, according to SBA. But that 3 days begin to count after you have successfully submitted all the required documentations, not the day you just turn in the application. You have to be sure that you have gotten the feedback from the SBA personnel that yes, you have fulfilled all the requirements for the application process, and then you can begin to count the 3 days. Now, you have to check, if you're applying online, there's a box you have to check that you need the emergency advance. Otherwise, you are not going to get it. If you don't check that, yes, you need the advance, it's not going to be made available to you. So please, when you're applying online, check that box that you need the 10,000 emergency advance. The advance you would not have to repay according to them, but that is subject to change. I was reading something yesterday that says now SBA is saying that the decision is rests with them. The discretion to decide whether you pay back or not rests with them. So, but typically, based on the information they have on their website, it says you will not have to pay back that 10,000 advance. Now, the interest on this loan depends on what category you fall into. If you're a business, the interest rate is 3.75, and the interest rate for nonprofit is 2.75. For PPP, I need to mention that the interest rate is 1%. And for this loan, EIDL, you have a maximum of 7 years to pay back. What must you spend the money on? You can spend the money on your payroll, rent, mortgage payments, other business obligations. Now, there is flexibility in the proportion of what you spend on payroll. Now, there's no limitation as to what percentage you have to spend on payroll. So you have the freedom to decide in what proportion you want to spend the money, unlike the PPP. But you must spend the money on like working capital to run your business. Now, what can't you spend the money on? You can't spend the money on paying dividend or bonuses. You can't spend the money as disbursement to owners or partners or officers or directors or stockholders, except the disbursement directly relates to direct services that these owners render to the business. Now, you can't spend the money on expansion of your facilities or acquisition of fixed assets. You can't use it to replace any damaged physical assets. You can't use it for long-term debt payments. You can't use it to pay down government loans, including SBA loans. You can't use this proceeds to pay down government loans. You can't use it to pay penalties for violating the laws. Of course, you can use it to pay your obligation to the IRS. That's the only exception they have. You can't use it for relocation purposes. So you have to pay attention to that, because if you if you use it for non-allowable purposes, not only that you have to pay back, you might be charged with fraud for deliberately using the money for unallowable purposes. Now, the next program is Express Bridge Loan Pilot Program. Who is eligible? If you are located in the United States for COVID-19, you are eligible as long as you can prove that you are impacted by the pandemic. Of course, that's is an open secret that everybody is affected by the pandemic. So the burden of proving that should not be heavy on any business within the United States. And then you have to meet the requirements for SBA 7A loan eligibility. What do you get? You get up to $25,000. That's the maximum you can get under the EIDL pilot program. And you don't need a collateral for this. Anything you are getting above, below $25,000 for SBA loans, you don't necessarily need any collateral. You have normally you have to apply and complete your application process within 6 months of a federally or a presidentially declared disaster. But for COVID-19, they're extending the processing period for as a period of 1 year. So you have up to March 13, 2021 to complete your application for Express Bridge Loan Pilot Program. What can you not use the money, the proceeds from Express Bridge Loan on? It is the same thing as you have for EIDL, except that physical disaster-related proceeds, you can use it for replacement of assets, replacement of physical asset that is damaged during the disaster. Now, going on to the last program, which is the SBA debt relief. Who is eligible? Now, we have two pieces to this. We have the payment portion and we have the deferment portion. The payment portion relates to payments of interest, principal, and fees on SBA loans. And then the deferment has to do with you not being required to make your typical regular instrumental payments. They are not going to pay the money for you, unlike the payment piece, but it's going to be deferred. You are not going to pay during the period of deferment. Your interest will still be accruing, but you will not have to pay. So who is eligible? Current and new SBA 7A 504 or micro loans holders. If you have an existing loan under this category, or you have a new loan that is approved before 27th of September this year, you'll be eligible for the payment. For deferment, if you have SBA disaster loan, home or business, that business, and that loan is in a service status as of 1st of March this year, your loan is eligible for deferment. So what do you get under the deferment program? Under the debt relief. As I mentioned earlier, you have payment portion, payment for 6 months of your principal, your interest, and your fee on your SBA loans that fall into those categories. For new loans, for the loan to qualify, it has to be processed and complete and approved before September 27th of this year. Now, for deferment, the deferment means you will not have to pay your interest, your principal, your fee until the end of this year. Now, your interest still goes on accruing, but you don't have to make any payments. Now, I need to mention, if you have set up an automatic payment on your account for the deferment purposes, if you want to benefit, you have to go and stop or cancel that automatic payment. And the same goes for the payment benefit as well. If you have automatic payment set up on your account, you have to go and cancel it. Otherwise, the payment will still be processed as normally, and that will defeat the essence of the deferment or the payment. So other than that, if you don't have anything set up on your account, you can just relax. The payment will be made on your behalf, or the deferment will be made automatically. If you need to confirm whether the deferment is being applied to your account or not, there's a number that is provided that you can call. Have that number on my website. So if you can, please go to the website and get more information, more answers to your questions. There are a lot of questions that are answered on the website that we don't have time for here in this webinar. But please feel free to go to the website and access those resources. You get more answers to your questions right there. And that's
Awesome.
my presentation.
Wow, great job. That's sure a lot of information, Michael. We've had a couple of questions come in, so I think we're doing great on time to allow for some. So I'm going to get started with one that I've actually had asked by several of my clients and colleagues who are out there. And I think the biggest, from an employee relations perspective, is, we hear terms like furlough, layoff, separation, right? Especially in light of now these programs that we can or cannot take advantage of, depending on the decisions we've made with our employees. So let me put it into kind of a perspective of a funnel, right? A funnel in that the top of the funnel has this title furlough. Furlough means this is allowing for as much of our workforce to continue to work in some way, shape, or form. A furlough is a reduction in hours, very, very different from a termination or a layoff, when those are completely separations from employment. So a furlough can be as little as, I have no hours for you right now, but it's not a termination, it's not a layoff, or I have only a reduced schedule, right? Maybe 30% of your hours, 50% of your hours, right? Putting them into a part-time status. So a furlough, an employee remains on your payroll. They remain eligible for benefits under your group health plan. They remain eligible for any PTO programs, but it can and it is a reduction in hours or the days of the week that the employee works. Now, this raises issues with exempt employees because obviously you may remove the exemption. So you want to discuss that with an HR consultant or your legal counsel, things of that nature. So that is a special designation. And again, we've got to look at your CBA, your local state laws, things of that nature. But a furlough really is just a reduction in hours or days of the week the employee works. A layoff is a termination in essence. A layoff, however, says that it may not be completely permanent, right? We may choose to bring them back, but we are in fact separating them from employment. They are no longer eligible for your benefits. This layoff may include one or more employees, as with a termination. And the layoff, the employee laid off is qualified for COBRA, for continuation of benefit purposes. So that needs to be coordinated. Oftentimes, when we terminate or lay off, which is the complete, termination of an employee, with the hope that you will bring them back, but that's unknown because we don't have a crystal ball, then that laid off employee is entitled to their final paycheck, their accrued vacation, PTO, sick, whatever it is that your handbook outlines, and COBRA as dictated, and of course anything subject to state law. So it's very much like a termination. A termination is the complete separation of that employment, of the relationship, with no expectation of that return. Now, you can always do a rehire later, but a layoff says, listen, we just don't have any hours right now. We're closing the book, if you will, on your employment, paying out any benefits, that kind of thing, with the hope that maybe we can bring you back at some point. But it is in fact a termination of employment. So So I've got a couple I know that came in for you. Michael, let me bounce it over to you for a question.
Sure.
So can the PPP, EIDL, and EBL be applied for collectively?
Yes, but you can't apply for more than one time under each program.
Ah, okay. So, and they coordinate together in a way, right? Especially when you look at the reasons for the use and things of that nature, like where the paycheck protection has a big, heavy paycheck portion, and the idle has a little bit more that you can use for business purposes, for business costs and expenses.
Right. And for if you have applied for the EIDL prior to applying for the PPP, you can transfer that money to your PPP. So you can add what you are owing, what you have on your EIDL as an existing loan if you have had it processed and approved prior to you applying for the PPP. So you can add what you have there to the amount you are applying for in your PPP program. So you add what you are owing under the EID to your payroll cost. They have a form. So you calculate your average monthly payroll cost, and then you add what you are owing under the EIDL if you have one, so that you can now consolidate. But then now you have to be cognizant of how much you spend on your payroll, because everything now comes under the PPP program.
Right. It looks like they shoved most of it into that program. So another question here, it's actually in much to the layoff question. Can I lay off staff and still apply for the payment protection plan? So you can apply, but in order to get the loan forgiveness, and Michael, please step in and correct me if I'm wrong, companies really do need to maintain their pre-crisis levels of full-time employees. And according to the last update that I received, small businesses have until June 30th of this year to restore your full-time employment and salary levels for any changes that you might have made between February 15th and April 26th. So, and that's for the forgiveness of the loan. So you can apply, you just may not be forgiven because you've got to bring those staffing levels up. Okay.
That's correct, Lisa. Part of the requirement for the forgiveness is that you maintain your employee level, in addition to spending at least 75% of the amount on payroll costs.
Excellent. So this one says, what do we do if an employee refuses to come to work? That's a loaded question, right? I'm going to sound like an attorney right now because it depends on the reason, the nature of the job, the risk factors. You know, again, OSHA protects workers from coming to work if they fear there are an imminent danger. And that's subject to interpretation and specific risk factors. But we all know what the risks are out there when we look at the CDC's recommendations. So are we keeping the area clean and sanitized? Has there been an exposure? Things of that nature all kind of play into it. Are they an employee that's high risk? Are they an employee who has a loved one or family member that is at high risk? So it's a very specific question. So it really does depend, but those are some of the things that need to be considered. I had a feeling we were going to get a lot of employee relations questions on this one. So Michael, how do I apply for the loans you mentioned?
For the EID program, you can apply online, and I'm going to post the link here right away. Or better still, let me post this link that has more comprehensive information on my website, and it has a link to the application page for the EID. And now for the PPP, you have to apply through your any participating bank. There is a form that you have to complete, and you have to add the other required documentations, and then you go to the bank that is participating in a program, and then you apply through them. For the debt relief, of course, like I mentioned, you don't need to do anything. If you have any eligible loan, it automatically applies to your account. For the express bridge loan, also there is a set of forms that you have to complete. I have those forms listed on my page on my website. So I just posted a link to that page. So if you are interested in applying for any of these, you get the required information from that page. And then if you still have any need for assistance, please feel free to reach out to me. I'm offering a free consultation and assistance relating to that.
Excellent, excellent. So another, I think my furlough layoff question kind of spawned some more questions. Can I furlough an employee and then lay them off? Yes, you can do that, right? Because there's that funnel again. We started with restricted work and now we have none. So you can do that. And for those of you who get my newsletter, you may or may not know, there is a new resource guide on my website, hblresources.com/COVID-19, and it is for notification of an employee that they're reducing hours or you have to lay them off, what have you. It gives you the document to kind of have that conversation. What the recommendation that we have given our clients on furlough is that you set a time frame to check back in, right? Because things are changing quickly. I recommend my clients that they say, I will check in with you every Monday, right? Because if that changes, you'll know on Monday, right? So that we have an opportunity to pivot our businesses as needed. And that document also provides tons of resources that you can provide to your employees in the event you have to have these conversations, okay? Another one here is, can we restrict employee travel? Yes, you can modify your travel policy as needed. You can advise your employees that they now have to do video conferencing. We see a big uptick in Zoom calls. Let's see what else. Something's just come in. If we laid off our employees, but let me read it through. We needed to rehire some of them as part-time as needed employees in order to attend emergencies. Would it be fraudulent if they apply for unemployment under these circumstances? Absolutely not. Unemployment compensation, we didn't get to touch on it much, has expanded quite a bit too. But there has always been the eligibility for employees who have a reduced hours of work to apply. That's almost nobody knows that, right? If suddenly, even for a hurricane, I lose a week's pay or 2 weeks pay, there's actually eligibility for unemployment under that situation. So yes, that individual can continue. It might get a little tricky with the documentation that you're providing because maybe they initially said that they were terminated and now they've been rehired. So there are some various eligibility questions loaded into that question. But yes, please encourage your employees to apply. A lot of the regulations that we're seeing now are also mandating that employers notify their employees that they may be eligible or in some cases are eligible for unemployment and even to provide the information. Now, we've always done that regardless COVID-19 or anything because as you know, our focus is ensuring that we have conversations with employees and they walk out of that with their dignity intact. So we're always going to recommend that you provide any and all resources, regardless if the law requires it or not. So give them all the resources to help them get back on their feet. There's some other great resources on that COVID-19 page on our website as well. So you'll see that on the navigation. Hopefully that gave you a little bit of your answer. But yes, they can still apply. There would be nothing fraudulent about that. Let's see. If my employee tests positive in the workplace do I have to close and cease operations? Great question. No, you don't have to cease operations, but there definitely are some things that you want to do in having the conversation with the employee, in having the conversation with the other employees in your location, and with what needs to be done under the CDC's recommendations for the facility. So I am working on a resource. I am going to share with you how we can get you that resource right after the webinar, but great question. So no, you don't have to close, but there are some things and a timeline that you should kind of consider in the event you have an employee who tests positive in the workplace or has been in the workplace and then tests positive. What other questions do we have? What collateral is required for the loan? Maybe
depending on which loan, for the PPP, you don't need any collateral. For the EIDL, you need a collateral if you apply for more than 25,000. But if you apply for something that is less than 25,000, you don't need a collateral. Now, for the Express Bridge loan, you can't get more than 25,000. So in that case, you don't need any collateral.
Great. So another question came in. Can employees under furlough apply for unemployment benefits? And the answer is yes. That is under that reduced work week, that reduced pay. You know, unemployment is there for the purpose of ensuring that an employee's normal income stays stable. When there is a long-term reduction of that income level, unemployment can step in. And keep in mind that, correct me if I'm wrong, CPA, you know, not just we as employers pay our portion of state unemployment taxes, so does the employees. So we share that cost, if I'm not mistaken. So go ahead and apply for those, because that reduction in hours reduces the income, and that provides where unemployment benefits can kick in. So we are right at the 2:59 hour. I definitely want to make sure that I say a special thank you to Michael Bayere for being on the call and coordinating the finance piece of all this. I stay in my lane, people, so I appreciate you bringing your expertise on that. I will definitely send out an email newsletter before the end of the week is up. It'll have the paper application for unemployment benefits, but get on my newsletter. That's the best way for all of you who are requesting it. I can't email dozens and dozens, but you can definitely make sure to get that from the newsletter that'll be coming out. Our contact information is here, and for those of you who may need some personal time one-on-one, Michael is offering a free consultation. Thank you for that, Michael. My clients are going to appreciate that if they can take advantage of that as they get acclimated and get to know you. I certainly have a high level of respect for you. For those of you who might be interested or might need some one-on-one consultation, because obviously this is a broad overview and we just can't cover it all in the unique situations, we've put together a workplace toolkit and resource guide. It is what to do after a COVID-19 diagnosis in the workplace. It is available to anyone who wants to schedule a 1-hour consultation and walk through their Q&As. And for those of you who are my clients, you know I try to chock full that hour. So definitely use the coupon code that is available for viewers of this webinar until April 30th. The coupon code is COVID, and this will link, that link will get you directly to my consultation page, which is also available on our website. So Michael, attendees, thank you so much for the time you've all taken to learn a little bit about what we are staying aware of and abreast of. We will continue to have these and keep you aware of all of the information that's coming fast and furious in these crazy times. Stay safe, stay healthy, and enjoy the rest of your day.
Thank you.